We've been talking about the First Amendment. There are two other really big First Amendment cases that we need to talk about, at least, before starting a conversation with our friends in the audience. The first and most closely watched was the Hobby Lobby case, which came down on Monday. Neal, tell us what Justice Alito held, and tell us whether you agree with him or with Justice Ginsburg, who found the decision startling in its breadth when it held that religiously motivated for-profit corporations are entitled to an exemption from the Affordable Care Act's contraception.
Great. And so the big point about this is not about Hobby Lobby, it's about Justice Alito. I mean, and Ted, you may agree with this, but as I go up and argue at the court, I've been struck each year by how good Alito's questions are, each time. I mean, they are so analytic, so powerful. And this term, I think we saw him emerge as a leader, not in the oral arguments, but actually in the written opinions. And so the last day of the term, usually those opinions are written by the Chief Justice or the second most senior justice. Justice Alito hands down both opinions, both in Hobby Lobby, which I'll talk about in a moment, as also Harris versus Quinn, the big public union case as well. So Alito has really, I think, emerged as a leader in this term. It's a really interesting thing to see. The question in the Hobby Lobby case is whether a closely held corporation that objects to the part of Obamacare that requires them to pay for contraceptive, the so-called contraception mandate, whether or not that violates religious freedom principles that Congress has laid down in a statute called RFRA, the Religious Freedom Restoration Act. And what Justice Alito said is, this is a corporation, it's a closely held corporation, they have rights too. Just like ordinary people, and they can, and this should not be surprising. As I said, elections have consequences. This is, I think, a position that this lineup on the court has held for a while. Ted, I think, was one of the leaders in pushing it in the Citizens United case. Corporations have first.
You mentioned Bush versus Gore and Citizens United. I'm going to be run out of town on a rail.
I told you. I think you've got some insulation. Stuff. We'll talk about your future in a moment, and I think they'll be perfectly happy with your advocacy. But at the end of the day, Justice Alito says 5-4 that corporations have these rights and that Hobby Lobby shouldn't be forced to pay for this contraception. And what they say is, look, the government has a less restrictive means available to it. The government can just pay for it. There's no reason to have the government forcing these religious corporations to have to pay for it. Justice Ginsburg, in her dissent, says this is a sweeping decision, that this is going to change the landscape of law, that employers are going to object to vaccinations and the like. She says it's not limited to just closely held corporations. It might apply to public corporations. There's no logical stopping point. So this debate is going to continue for a long time. It's a full employment act for lawyers, to be sure. But this is one in which the court was closely divided, and Alito really leads the court in a certain direction.
Ted, Neal referenced the Citizens United case where you successfully argued.
So you're going to rub it in.
No. Well, I promised a nonpartisan debate here in Aspen, Colorado. Citizens United Justice Kennedy held that corporations have the same First Amendment rights as natural persons when it comes to campaign finance spending. Hobby Lobby was not decided on constitutional grounds. It was the Religious Freedom Restoration Act. Do you feel, however, that a majority of the Supreme Court is sympathetic to the idea that corporations have First Amendment free speech and religious liberty rights?
Well, first of all, the question is, do corporations have constitutional rights under the Bill of Rights? And that sort of became an issue after Citizens United, because people were very unhappy with Citizens United because some of the people said, well, corporations aren't entitled to constitutional rights under the Bill of Rights. But the Supreme Court had held dozens, scores of times, and there's footnotes elaborating all these decisions, that corporations do have constitutional rights. One of the leading cases, notwithstanding the New York Times' editorials against Citizens United, was a case called New York Times versus Sullivan. And another one was the United States versus New York Times, which was the Pentagon Papers case, in which the New York Times really did think that they had constitutional rights, and they won. And corporations have rights against searches. They have rights when the government wants to take property of corporations. So that was one issue. The other issue in the Citizens United case, and there's many, what another issue was, that was a nonprofit ideological corporation. It wasn't a big public shareholder. Speaking of closely held corporations, that was pretty much, that was a very, very tiny little corporation that wanted to make a movie about whether or not a particular person should be qualified to run for president. Now, this case is rather interesting because it extends, or it talks about the rights of, it was a statutory case, not a constitutional case, but it talked about whether or not corporations can have religious views. I'm sort of sympathetic to the dissent in this case, because, and I was thinking as we were talking about it just this week before the decision, that, and they talk about the corporation might be against vaccinations. What about the Christian Scientists, you know, against doctors, you know, and I'm maybe not stating their doctrine correctly, but you can see people in having those kind of views saying, I don't want to pay for insurance for my health insurance for my employees at all. I don't know where the line can be drawn, and we're Justice, the pivotal point here, this is really a 4-1-4 decision. Justice Kennedy writes a relatively short concurring opinion, putting oil on troubled water, saying it's not going very far, it's not going to happen with public corporations, it's just closely held corporations, it's just this one particular piece of insurance, it's not all kinds of insurance, and all of those things. But I agree with Neal, this is just a minefield for lawyers. What in the world is a closely held corporation? I mean, how many shareholders, or how many small a number is it? And when you get, does the corporation have religious convictions? Certainly its owners do, but they have decided to engage in commerce. So it's got a lot of issues that people are going to be litigating for years.